All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Madam Court Officer, please call the case.
Good morning, Your Honors. This is file case CBC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
I note that all accused are present in court today except for Mr. Krasniqi, who is attending via video link. Today we were supposed to start hearing the evidence of prosecution witness W04747. However, I understand that the witness is not able to make today's hearing and that the SPO intends to offer the witness's evidence under Rule 155 instead. Mr. Prosecutor, is there a need to go into private session before we hear from you?
There is, Your Honor.
Please into private session, Madam Court Officer.
Your Honors, we're in public session.
I'll take the opportunity afforded us to issue some oral orders. First, the panel will rule on the Vasily defense request for relief, which is filing F02968. On 27 February 2025, the Vasily defense requested that the panel order the SPO to disclose all contemporaneous notes taken by those present during the preparation session of W04745. According to the Vasily defense, W04745 claimed during his testimony before the panel that the SPO had shown him a document during the preparation session and that based on the description of the document provided by W04745, the document in question may have been internal SPO work product. The Vasily defense argues that it was surprised to learn that preparatory sessions are not audio-video recorded, that this itself necessitates the disclosure of contemporaneous SPO notes of the preparation session. The Vasily defense argues that these notes are necessary for the panel to assess the credibility of the witness and to understand why W04745 stopped answering the SPO's questions during his direct examination. On March 4, 2025, the SPO responded that the Vasily defense request should be summarily dismissed. According to the SPO, it is clear that the document to which W04745 repeatedly referred in his testimony is a prior statement of the witness from 2001, which the defense already has, and that the Vasily defense has failed to demonstrate how additional notes could in any way shed further light on the matter. The panel notes that the Vasily defense relies on a selected portion of W04745's testimony to support its contention that the document referred to by W04745 may be an internal work product of the SPO. Having reviewed the record as a whole, the panel finds no support for the Vasily defense contention. It is clear from W04745's testimony, the SPO's preparation note, and 4745's 2019 interview with the SPO that the document in question is the witness's 2001 statement, which has been disclosed to the defense and is not internal work product of the SPO. The panel observes that W04745's refusal to answer the SPO's questions during his examination clearly related to his 2001 statement. W04745's reaction in court when shown his 2001 statement was consistent with his reaction on previous occasions when he was shown the 2001 statement. The panel is therefore not satisfied that the document W04745 referred to may have been the SPO's contemporaneous notes or internal work product as claimed by the Vasily defense. In respect of the Vasily defense's submission that it was surprised to hear that preparatory sessions are not audio or visually recorded, the panel recalls that it considered in detail and rejected a defense request that the SPO audio and video record witness preparation sessions in its decision on joint defense request for amendment of the order on the conduct of proceedings, which was filed on 18 June 2024. In addition, the panel notes that the SPO's submission that it has provided the defense with all documents shown to, read by, or discussed with W04745 during his preparation session. There is no information before the panel that would contradict his assurance. Consequently, the panel finds that the requested disclosure is not warranted. The request is accordingly dismissed. The panel instructs the Vasily defense to request reclassification or public redacted versions of the request, which is F02968, and the reply, which is F02988, by Tuesday, 8 April 2025, and instructs the registry to reclassify as public the SPO's response by Friday, April 4, 2025. This ends the first oral order. Number 2 will be an oral order on the reasons for admission of evidence of 4745 pursuant to Rules 143 2B and C. The panel will issue the reasons for its decision of 25 February 2025 to admit 4745's prior statement and preparation note with 3 associated exhibits tendered by the SBO pursuant to Rules 143 2B and C. W04745 testified in these proceedings on 24 and 25 February 2025. On 25 February 2025, during its examination of 4745, the SBO requested that 4745's statements from 2001 and 2019, or portions thereof, and the preparation note with 3 associated exhibits be admitted pursuant to Rule 143, Paragraph 2, subparagraphs B and C. The defense objected to the admission of this evidence under that rule. The Thaçi defense noted, however, that should the panel admit 4745's evidence, appropriate redactions should be applied. On the same day, having considered parties' submissions, the panel admitted 4745's prior statements and the preparation note with the associated exhibits pursuant to Rule 143 2B and C as P02079.1 to P02079.17, also P02080, P02081, P02082, P02083, and P02084. The panel now provides its reasons for that decision. The panel notes that Rule 143B2 provides for the possibility of questioning a witness who is not making a genuine attempt to give evidence as a matter or on a matter of which he may reasonably be supposed to have knowledge. In relation to the 2001 statement, which the witness commented on during his 2019 interview with the SBO, as well as his preparation session, see for example, transcript page 25502, the SBO made significant efforts to show the 2001 statement and for avoidance of doubt, any other statement or notes to W04745 in relation to the 2019 interview. The panel considers that 4745 stood by this interview. That's transcript page 25505. Notwithstanding any purported ambiguity in paragraph 6 of the preparation note, as argued by the Thaçi defense. Nevertheless, the SBO was unable to examine the witness in relation to the greater part of his prior testaments. Transcript pages 25506 and 25516. Despite being warned by the panel that he could be in violation of the court's orders if he failed to answer questions. That's transcript pages 25529 and 25530. Furthermore, 4745 explicitly indicated that he would only answer questions from the defense. That's at transcript pages 25588 and 25590. The panel therefore considers that the conditions under Rule 143 2B are satisfied. The panel further considers that Rule 143 2C provides that prior inconsistent statements may be admissible for the purpose of assessing the credibility of a witness as well as for the truth of its contents, or for other purposes within the discretion of the panel. The panel recalls that a lack of genuine attempt to provide evidence can constitute a prior inconsistent statement. For example, F01821, paragraph 49. In this way, Rules 143 2B and C can be read together and may overlap in part, as in the present case. The panel notes in this regard that the parties agree that W04745's 2001 statement contains inconsistencies with the witness's other evidence, which is transcript pages 25575, 25576, and 25583. The panel is also satisfied that W04745's lack of genuine attempt to provide evidence on matters he commented upon in his prior statements and preparation note rendered his 2019 interview and the preparation note with the associated exhibits inconsistent. Regarding the admissibility of W04745's prior statements and the preparation note with the 3 associated exhibits, pursuant to Rule 138, the panel notes that this evidence is relevant to the facts and circumstances material to the charges in the indictment, in particular in respect of the structure, organization, and hierarchy of the Kosovo Liberation Army, as well as charged crimes. The panel therefore finds that 4745's prior statements, the preparation note, and the associated exhibits are relevant to these proceedings both in respect of the information which they contained and assessing the credibility of the witness. Regarding authenticity, the panel first notes that the Krasniqi defense disputes that the 2001 statement qualifies as a statement, given that W04745 denied giving that statement. The panel recalls its earlier decision, which is filing F02580, at paragraph 10, where it found that an investigative note prepared over a course of a criminal investigation which reproduces information provided by a witness qualifies as a statement. The fact that a witness denied making the statement has no bearing on such finding. The panel is satisfied that 4745's 2001 statement meets these criteria, given that it was produced by investigators over a course of criminal investigations, and the statement reproduces information provided to the investigators by 4745. The panel further notes that 4745's 2001 statement contains multiple indicia of authenticity and reliability. It is dated, includes the names and signatures of the relevant investigators, 4745's personal details, and is included on an official template. Additionally, the panel notes that the parties agree that the 2001 statement contains certain inconsistencies. That would be at transcript pages 25575, 25576, and 25583. Nevertheless, the panel recalls that it will be for the panel at a later stage to assess the witness's credibility and the reliability of his statements in light of the entire body of evidence admitted before it at trial. In accordance with Rule 139.2, it will consider any such inconsistency between successive accounts in that context. The panel notes that 4745's 2019 interview contains multiple indicia of authenticity and reliability, including the fact that the transcript of the interview was audio and visual recorded. The dates of the interview and the identification of the attendees are clear. The witness was under an obligation to tell the truth, and the witness made the requisite acknowledgments that he had been truthful. Similarly, the preparation note contains the dates of the interview and an identification of attendees. The witness was also duly informed of his rights. The panel is further satisfied that the associated exhibits, which consist of a sketch drawn by 4745 and 2 reports, bear multiple indicia of authenticity. In particular, the 2 reports are dated, signed, and provided relevant reference numbers. The panel is also satisfied that the associated exhibits form an inseparable and indispensable part of 4745's evidence, given that the sketch as well as the 2 reports were commented on by W04745 during the preparation session. Concerning the Vasily defense's argument that the preparation note contains new evidence, that's transcript at page 25546, The panel observes that while the documents contained in paragraph 120 to 142 of the preparation note do not appear to have been shown to 4745 during his 2019 SPO interview. The panel notes that the substance of these issues discussed with 4745 were also raised in the 2019 SPO interview. In addition, the defense had every opportunity to cross-examine the witness on this material and chose not to do so. In relation to probative value and prejudice, the panel recalls that all defense teams were afforded the opportunity to cross-examine the witness. The defense will further have the full opportunity to make submissions regarding the weight to be given to 4745's prior statements, preparation note, and associated exhibits in its final trial briefs and final submissions. The panel is therefore satisfied that the probative value of W04745's prior statements, the preparation note with the 3 associated exhibits, is not outweighed by their prejudicial effect. This concludes the panel's reasoning for admitting pursuant to Rules 138 and 143(2)B and C, W04745's prior statements and the preparation note with appropriate redactions as agreed between the parties, as well as the 3 associated exhibits. This concludes that oral order. Can you tell us a reasonable date to have your motion on file as in regards to today's hearing?
I believe we can do it today, Your Honor.
All right. The reply will be then as is standard.
Your Honour, can we wait till we receive the request before deciding whether we would seek any further time to respond? We haven't received it yet, so once we receive it, we'll obviously inform you if that's something that we require. But
Yeah, I assumed you would anyway, so that's
it's just
fine.
to not prejudge that we may
We're
need
not
extra
prejudging.
time, depending on what other motions are filed, because we are expecting other significant bar table motions in the coming days as well. So just to preempt that, thank you.
I wasn't trying to prejudge your motion.
Much obliged.
We will certainly hear anything you raise. Anything further from the prosecution today?
None, Your Honor. Thank you.
From the defense?
Nothing, Your Honor.
Your Honour, can I just mention?
Yes, certainly.
We have, I think, 6 documents still MFI'd over the course of the trial, and I just wanted to highlight that we believe there are some rulings outstanding on those.
I believe we have a list, and we will rule on those.
I'm grateful. I
Thank
was
you.
sure that was the case.
Thanks for
but I
the
just
reminder,
wanted-
though. It's no problem. Anything further from the bench? So we are adjourned. We will reschedule the next hearing. I assume it will not be on the 15th of April because there's going to be some people missing. So we will do this shortly after that. We will schedule it and notify everybody. And we will, at that time, take the next step, assuming that you have rested your case by that time. So we'll be in touch. Thank you. We're adjourned.
All rise.